findings, we worked with fellow privacy commissioners across Canada to develop joint guidance for police use of facial recognition, meant to assist police in ensuring any use of the technology complies with the law, minimizes risks, and respects privacy rights. We are releasing the final version of the guidance today. As part of this work, we launched a national public consultation on police use of facial recognition technology. During this consultation, we heard consistently that the current laws regulating the use of facial recognition did not offer sufficient protection against the risks associated with the technology. While all stakeholders we consulted agreed the law must be clarified, there was no consensus on the content of a new law. Legislators will therefore have to decide how to reconcile various interests. Following this consultation, fellow provincial and territorial privacy commissioners and I believe the preferred approach should be to adopt a legislative framework based on 4 key elements, which we have outlined in a joint statement we're issuing today. First, we recommend that the law clearly and explicitly define the purposes for which police would be authorized to use facial recognition technology and prohibit other uses. Authorized purposes should be compelling and proportionate to the very high risks of the technology. Second, since it is not realistic for the law to anticipate all circumstances, it is important, in addition to limitations on authorized purposes, that the law also require police use of facial recognition to be both necessary and proportionate for any given deployment of the technology. Third, we recommend that police use of facial recognition should be subject to strong independent oversight. Oversight should include proactive engagement measures, such as PIAs, program-level authorization or advanced notification before use, and powers to audit and make orders. Finally, we recommend that appropriate privacy protections be put in place to mitigate risks to individuals, including measures addressing accuracy, retention, and transparency in facial recognition initiatives. I encourage you to consider our recommendations as you complete your study of this important issue.
So in the joint investigation of Clearview by the Privacy Commissioner of Canada, the Information and Privacy Commissioner for British Columbia, and the Information and the Privacy Commissioner of Alberta, the offices recommended that, 1, cease offering the facial recognition services that have been subject of this investigation to clients in Canada. 2, cease the collection, use, and disclosure of images and biometric facial arrays collected from individuals in Canada. And 3, delete images and biometric facial arrays collected from individuals in Canada in its possession. Has Clearview taken any of these actions?
Clearview has stopped offering its services in Canada, I believe in 2020, while we were still investigating. But it is in court challenging the decisions of my colleagues, I believe because they do not want to give an undertaking in perpetuity that they will not offer their services. But at this point, they are not offering their services in Canada.
Thank you.
Now, for 5 minutes, Mr. Williams.
Thank you, and through you, Mr. Chair, to Mr. Therrien as well. As you mentioned last week, we had the RCMP, and in response to findings that the RCMP's use of Clearview AI was illegal, they say they disagreed with your findings. A representative reiterated that stance. Does the reason for disagreeing with your findings have any merit? Why or why not?
I'll give a lawyerly answer, which I think will be clear. The provision at play is the provision of the Privacy Act that governs the collection of information here by the RCMP. What the RCMP is saying is that section 4 of the Privacy Act, does not explicitly require a federal institution such as the RCMP to ensure the legality of the practices of its commercial partner before the public sector uses the information. It is true that Section 4 does not explicitly require that of federal institution. We think that that requirement exists implicitly. Essentially, imagine federal institutions would be able to contract out, would be able, through contracting with the private sector, to engage in practices that it cannot engage directly. That is unacceptable. We think the law does not allow for that. That said, so is it credible or is it reasonable? There is some credible basis for the RCMP's position. To the extent that there is ambiguity in the law, I would encourage you strongly to close that loophole and to require government institutions, not only the RCMP, but all government institutions, to ensure when they rely on the private sector that what they're buying is lawful.
Thank you. And I guess the follow-up question is, should the powers of your office be strengthened so the rulings on Privacy Act violations are binding and properly enforced, since they seem to have ignored them?
Short answer is yes. We've recommended that many times, yes.
Facial recognition technology. So I'm wondering what sort of advice you have for legislators to be flexible in the legislation so we don't have to rewrite the legislation every time a new piece of technology comes. How do we make it flexible so when there are more advancements in technology, the legislation still applies?
Question. My starting point would be to say that we do have laws, obviously. We have the Charter, we have the common law, there are some statutes like the RCMP Act that govern the situation. And in the private sector, we have PIPEDA. To your point of flexibility to ensure that a law does not become obsolete, one of the virtues of PIPEDA is that it is principles-based. So it does not seek to regulate particular situations. It deals with principles. But I think for facial recognition, that is where we start to see the limits of the virtues of a principles-based approach. Because if you regulate facial recognition by saying it ought, the user ought to be accountable, or principles of that nature, or necessity and proportionality apply, that leaves a lot of discretion to the police to exercise these broad principles in a way that suits their interests. So I'm not saying that there ought not to be principles-based legislation. As a general principle, it makes a lot of sense. But in the case of facial recognition, because of the extremely high risks to privacy and other rights, such as democratic rights of demonstrating or equality rights, we say that there ought to be specific provisions, for instance, in the case of the police, to prohibit uses except in certain circumstances. So a good grounding of principles-based legislation makes sense, but in the case of facial recognition, with an addition of a few specific rules that ensure that the broad principles are not, I'll say, abused or not interpreted in an overly generous way.
Would this apply to public spaces, the use of facial recognition in public spaces as well?
Yes, the rules that the recommendations that we're making would apply to public spaces as well.
Thank you. I'd like to, if I could, just move into personal information protection, electronic documents, which is something I've had a lifetime working with. So currently, the technology, it's technology neutral, which allows it to endure over time. Should a technology neutral law apply to facial recognition technology?
We're back to the question I answered a few minutes ago. So principles-based technology neutral legislation for the private sector makes sense as a starting point. The reason we're recommending that for police forces there be specific legislation has to do with the harms of that particular technology of facial recognition. It may well be that certain uses of the technology by private companies raises extremely high risks not only to privacy but to other rights. Clearview is a good example of that. We call that mass surveillance. Mr. Fergus referred to other circumstances. I agree that to denote emotions in order to sell a product or whatever other purpose should not be allowed. I would encourage you to, so we'll provide a few examples of good pieces of legislation. There's a draft legislation in the European Union, not yet adopted, which is a good model, obviously to be adapted, and it says, among other things, that facial recognition should not be used to violate human rights, and that applies horizontally, whether to the state or to private companies. That is something I think that Canadian parliamentarians should seriously consider.
I think there's an understanding that there is certain times that we want to use FRT for police enforcement. How those images are harvested, like scraping social media, is that something that should be banned?
That's the issue that we looked at in Clearview. So if you're within a category or circumstance where the police should be able to use facial recognition and rely on the technology of a private sector partner, we think that the police should ensure that the private sector partner has acted lawfully. And to scrape data from the internet on social media, regardless of the privacy settings of a consumer, for instance, would not be lawful. So that should not, even for serious crime, that should not be possible.
I agree, and I would simply add that mass surveillance is the area that caused us the greatest concern on behalf of all federal, provincial, and territorial commissioners, and that's whether it be done by a private sector, third-party private sector company on behalf of police service or the police service itself. This is an area that we've highlighted in particular as worrisome.
Pour ma part, j'ai rien à ajouter.
Threats of national security.
I would go back to my general point. Yes, we have investigated the link between Facebook and Cambridge Analytica. We have studied and the use by Cambridge Analytica of data, in some cases, to try to influence political processes. There can be also other nefarious uses. I think it's high time. The lesson is it's high time to stop looking at privacy as a technological issue for the very few, and to look at the use of technology, particularly when it collects personal information, for the link of these technologies with fundamental rights, and to legislate accordingly.
Okay, and I certainly, Mr. Chair, in wrapping up,